We welcome all of you who are joining us today for this call live. And for those who have RSVP'd and had work emergencies arise, we are recording this and we'll send the recording out to them. So let's get underway. On Wednesday, March 24d, the North Carolina General Assembly pushed through sweeping legislation to ban LGBT non-discriminatory ordinances throughout the state. They also passed the law that will overturn any existing protections that are already in place. And moreover, they prohibited transgender individuals from using public restrooms and locker rooms corresponding with their proper gender identity. House Bill 2, also known as the, quote, Public Facilities Privacy and Security Act, close quote, was signed into law less than 10 hours after it was introduced and was passed in a special emergency session of the state legislature. Critics of the law have called it the most anti-LGBT law in the country. The legislature was not originally scheduled to convene until late April, but North Carolina GOP leaders scheduled a special session on March 23rd. It is estimated that that special session cost North Carolina taxpayers $42,000. The architects of the law said they wanted to stop a new ordinance in Charlotte, North Carolina that had been set to take effect on April the 1st. The local ordinance prohibited discrimination in housing and public accommodations based upon sexual orientation or gender identity expression. And proponents of House Bill 2 drew on the many very, very sad and extremely harmful stereotypes of transgender people, particularly our trans sisters, and we're seeing similar so-called bathroom bills around the country. So we are going to examine what exactly happened in North Carolina and what can LGBT organizations and advocates nationwide learn from this dreadful and scary legislation. Our two experts, again, are Shannon Minter, who's the legal director, and CLR. Shannon is a longtime LGBT advocate and has served as lead counsel for any number of high-profile LGBT cases, including the 2009 Prop 8 case in California Supreme Court, Christian Legal Society versus Hastings in remarriage cases, et cetera, et cetera, et cetera. Minter has been the recipient of a number of awards, including California's Attorney of the Year in 2009, and was listed as one of the 6 Lawyers of the Year by Lawyers USA, and has received the LGBT Bar's Dan Bradley Award as well. Dr. Maxine Eichner is a professor at the University of North Carolina at Chapel Hill School of Law. She focuses on the intersection of law and political theory. She covers a wide range of areas, including family relationships, social welfare law and policy, feminist theory, sexuality, and the relationship between the family, the workplace, and market forces. Dr. Eichner is an editor of Family Law Cases, Text Problems. It was published originally in 2014. So without further ado, Shannon, I believe you're going to start us off with where we're at with this law, and please proceed.
Well, I think Professor Eichner was going to take the first stab at just describing what it does. Yeah.
Okay.
I'd be happy to
Professor
do that.
Eichner.
Greetings all from the formerly great state of North Carolina. As Darcy told you, the House Bill 2, which is officially called the Public Facilities Privacy and Security Act, got passed last week. For those of you who want to find it quickly online, if you enter North Carolina HB2 in text, you will come up with the text of it. The new law is a reaction to a local ordinance that Charlotte passed late last month, which did 3 things. First, it changed law regarding the private contractors that the city could deal with to add 3 categories to the categories, the protected categories, sexual orientation, gender identity, and gender expression. Previous law regarding Charlotte said that the city could contract only with businesses who didn't discriminate in employment based on a range of categories like race and sex. All this law did, and it with respect to that, was to add the 3 categories: sexual orientation, gender identity, and gender expression. Second, the Charlotte Ordinance added the same categories, sexual orientation, gender identity, and gender expression, into its law prohibiting discrimination in public accommodation. And third and finally, the ordinance removed an existing statute from Charlotte's public discrimination ordinance that had said that the ban on sex discrimination, which had previously been in law, didn't extend to bathrooms and similar facilities. So by pulling that language out, Charlotte said that Charlotte pulled its approval of sorting bathrooms based on sex and left that issue uncovered by law. After the passage of the law, based on the perceived great public threat to women and young girls who could serve as prey in public bathrooms, our legislature snapped into action, passed a law in record time. Legislators were given 5 minutes to read the bill at the start of the session. A public hearing was held that lasted all of 45 minutes, at which folks testifying were confined to 2 minutes. In the state Senate, the Democratic senators walked out in protest at the time of voting. So that passed with only Republican votes. In the state House, it passed 86 to 26. All the Republicans present voted for it. 11 Democrats broke rank and also voted for it. The law passed goes certainly far beyond the repealing the Charlotte ordinance. First, it provides that in all public schools and public buildings in North Carolina, including in the UNC university system, any bathroom that can hold more than one person, all locker rooms, have to be designated as male or female, and they can be used only by people designated as that sex on their birth certificates. In North Carolina, one can get a sex change on the birth certificate, but only if they've had surgery. The second thing that HB 2 does is it preempts municipalities' ability to pass ordinances that set the minimum wage for employers generally and also set non-discrimination standards for businesses contracting with the municipality. You might ask why the minimum wage provision is in there, and of course, since there has been so little transparency on this law, nobody is quite sure. But the suggestion is that this kept the North Carolina Chamber of Commerce from coming out in opposition to the bill. The third thing that HB 2 does is it preempts localities from implementing any protections against discrimination in either employment or public accommodation. It provides that all those anti-discrimination statutes will be set by state law, and when it comes to the state anti-discrimination standard for employment, conspicuously absent is sexual orientation or gender identity, and the North Carolina General Assembly refused to add those categories in. The only change that it makes with respect to employment from its previous public policy is to add the word biological before the protected category of sex, apparently to make certain that category, that the protection given to sex isn't read in terms of sexual identity or sexual orientation. Turning to the state standard for public accommodations that HBO sets up for the first time, once again, it protects a number of categories like race and biological sex, but specifically does not cover sexual orientation or gender identity. The aftermath of what's happened in North Carolina, we have seen a lot of pushback during the week. In an impressive display of speed, 5 days after the law passed, the ACLU and Lambda Legal filed a 45-page complaint that contests the constitutionality of the statute. 3 states have prohibited public employees from non-essential travel to North Carolina on the public dime. The state attorney general, Roy Cooper, who's also running for governor, says he won't defend the law in court. There have been protests in a number of cities. 100 corporate executives from some of the biggest companies around the country have signed a letter asking for repeal to Governor McCrory, North Carolina's governor. Dozens of customers have pulled out from going to the High Point Furniture Market. Athletic associations are saying they would reconsider future events in North Carolina. The rest of us, lawyers in North Carolina, are still trying to figure out what this law means. Let me turn this over to you, Shannon.
Thanks so much, Professor Eichner. Yeah, it's really quite an extraordinary law, and it's somewhat complicated, as I think Professor Eichner's description pointed out. I think of this law as doing two broad categories of things, both of them very extreme and both very harmful. I mean, one is completely taking away the ability of localities in North Carolina to enact protections for sexual orientation, against sexual orientation and gender identity discrimination, as Professor Eichner noted. That is it's a devastating development, because as we've seen in other states across the country, the way that statewide protections on those bases are typically enacted are by building on localities in the state, passing local laws, and then that lays a foundation in terms of public education and visibility, with people, at least in some places in a state, feeling that they're protected enough to come out and be visible and active in the political process. It really helps change the climate in a state, and then eventually we're able to get statewide protections. So taking that away has a really devastating political impact. And of course, that was exactly the reason that the legislature did what it did, in order to make it unlikely that the state would ever enact protections on those for LGBT people. Well, that's one really bad thing the law does. And then the other thing that and I should say that North Carolina was not entirely unprecedented in doing that. Tennessee passed a similar law in 2011, and along with Abby Rubenfeld and the law firm of Morrison and Forster, NCLR, we did file a challenge to the Tennessee law in state court. I can maybe, Darcy, if you want to, we can talk a little bit more about that later. That lawsuit was inconclusive. It was dismissed on standing grounds. The state courts there ended up holding that the plaintiffs that we represented did not have standing to bring the suit. So no court has ever reached the merits of whether the Tennessee law is constitutional, and we might well be bringing a federal court challenge to that law at some time in the near future. But Tennessee does have a similar law. Arkansas also passed a similar law, although whether or not the impact of the Arkansas law is still being litigated, and actually there was recently a trial court ruling by a state court in Arkansas holding that Arkansas's law actually did not have the effect of preventing localities from enacting local LGBT protections. So, we're hopeful about that. But anyhow, it's almost unprecedented. There's only a couple of other states that have done what North Carolina just did on the localities power issue. But the other thing it did is entirely unprecedented, and it's really shocking, really extreme. It really just kind of boggles the mind. But the law purports, at any rate, to require all public schools, all public employers, all government agencies, publicly owned buildings to impose a very draconian rule about access to bathrooms for transgender people. And the rule requires that all of those government entities restrict bathroom access, as Professor Eichner noted, based on so-called biological sex, which the law defines as the gender marker on a person's birth certificate. And then I'll come back to that in a moment, but then with respect to private employers and private businesses, the law does not purport to mandate that they adopt the same policy, but it does say they are free to do so, and that if a private employer or a business chooses to adopt that same restrictive bathroom access rule, that they can't be held liable under state law. So this has never happened before. It's really extraordinary. And Professor Eichner mentioned the lawsuit that was filed just Monday of this week by Lambda and the ACLU, and they are representing Equality North Carolina and also some individual plaintiffs, two transgender men who one is a teacher and one is a student at the University of North Carolina, and then I believe a lesbian professor who also works for the university. And they are arguing, they're challenging both halves of the law, both of the two components that I just described. They're alleging that the first component, taking away the power of localities to enact anti-discrimination protections, violates the requirements of equal protection because it's based on bias against LGBT people, and the federal Constitution doesn't permit laws to be enacted based on a desire to harm a particular group. But then they're also challenging the bathroom provisions of the new law by alleging that they conflict with Title IX, which they certainly do. Title IX, the federal law that prohibits sex discrimination in publicly funded schools, including universities, colleges, and K through 12 public schools. The Department of Education has said that Title IX requires schools to give equal access to transgender students when it comes to bathrooms and locker rooms. So this law creates a very direct conflict between state law and federal law, and as everyone on the call is a lawyer, as we all know, when that happens, federal law prevails. And so this is really just an really extraordinary situation where a state has enacted a law that on its face, in a very sweeping and systematic way, purports to direct all government entities, including schools, to violate a federal law. So I think that it's a very strong lawsuit, and I'm hopeful that we will get a good ruling from the federal district court. Darcy, I'll stop there because I know you had some questions.
I do. I note since we started planning this call, corporations like American Airlines and Bank of America, Marriott, Yelp, PayPal, Microsoft, Apple, Uber, and even the NBA seems to be having opinions on this, as well as the state travel bans. Professor Eichner, does it help at all to know that the nation is galvanizing around your law, and do you think this will would be helpful in an economic context if we move outside the lawsuits for a moment?
I do think at the very least, I think it may be helpful. What the leadership in the General Assembly has been responsive to business interests when they haven't been responsive to other interests like claims for equality, claims for human dignity, claims for fairness. With that said, they did last year when they were considering amending North Carolina state law to make more accommodations for religion. They backed off on that when companies protested. One of the suggestions about why the General Assembly moved so quickly on this was to avoid business protests before. Now we have to wait to see if it will have any effect after the law has been passed.
And it's interesting, I believe you said that your highest state's attorney has stated they will not defend this law in court. Is that what you referenced earlier?
I did. Our Attorney General, Roy Cooper, has on past occasions defended laws even when he disagreed with them personally. And this one, he thinks the conflict is so great that he's refusing to defend it.
That's fascinating. So where would the state go to get someone to defend the law in court?
The General Assembly leadership has spent an awful lot of money on outside counsel, and clearly it will do so again on this issue. Interesting.
Let's go back. Shannon, you were talking about the Tennessee law, and you wanted to put a placeholder on that one. Can we explore that for a moment? I believe we're going to the top of the hour. We're not yet halfway through the hour, and we've got lots here to get through. But as we're talking about Tennessee's law, I think we might want to try to get some type of a timeline in mind. Insofar as you mentioned Arkansas, we already have a trial court ruling. We have matters out in Georgia, and there's how many more bathroom bills are in legislatures right now? Do you have an idea as we look back to Tennessee? May I ask you also to try to give us a timeline of when we're going to be hearing about this and other laws?
Wow, that's a great question, Darcy, because as I'm sure everyone on this call is painfully aware, the pace of justice is not always that swift, and that litigation can take a very long time. Yeah, it's been rather disheartening in Tennessee that even though that law was passed in 2011, and we filed our lawsuit rather promptly after that, but immediately became bogged down in having to brief and litigate issues around standing and have the standing issue go up to the Tennessee Court of Appeals. And long story short, here we are, 5 years later with no ruling on the merits yet. So, it is possible for these cases to become bogged down. Mm-hmm. That said, I am much more optimistic about the timing, the likely timing of the new case filed in North Carolina. I think the fact that it's filed in federal courts will help move things forward more swiftly. I do believe that, the complaint filed indicated that the plaintiffs intend to seek a preliminary injunction, so I imagine that they will file a motion for a preliminary injunction in the relatively near future. That said, I imagine they're also going to want to take enough time to make sure that the trial court judge, the district court judge, has a very robust record that I'm sure will include some presentation of expert evidence about the harmful impact of this law. I'm not sure of the exact timing, that's for sure, but I bet that we will see some kind of decision on a PI motion from the federal district court in the next few months, and then I'm certain that will go up to the Fourth Circuit, probably no matter which way the court rules. And then the Fourth Circuit, fortunately, is known to be one of the federal appellate courts that moves more quickly than others. So I am hopeful that this North Carolina law will this time next year, if all goes well, we might very well have a Fourth Circuit ruling either affirming or holding for the first time that it violates the federal Constitution and federal statutes. I hope so.
Frightening for those of us who are worried about particularly self-identified transgender law students throughout North Carolina. We're concerned about people's safety, and it does seem like this is going to take an awful lot of time. If you have questions, please send them to info@lgbtbar.org. Any questions, you can send them to info@lgbtbar.org. And here's a question from one of our best critical thinkers. HB2 does not include any enforcement provision, but in the legislature's hearings on the bill, one of the sponsors suggested that transgender North Carolinians who tried to use a public restroom would be in violation of the state's criminal trespassing laws. Do we believe that is the law that officers would use should such a situation occur? And in fact, which degree of trespass do we have an understanding would be applicable? It seems that that's yet another flaw in a hastily crafted law. There doesn't seem to be any understanding whether this would be second degree trespass, the lowest level, and class 3 misdemeanor, which is apparently 20 days of jail time and a fine up to $200, or would this be treated as first class, which is 60 days and a $1,000 penalty? Any guesses, Professor Eichner, what degree of trespass would apply, and do you think that will be the enforcement provision applied here?
So we are struggling to figure that out. My guess would be that it is second-degree criminal trespass, which is a misdemeanor. But some people are suggesting that the statute that prohibits indecent exposure could possibly apply. that requires exposing one's private parts. I can't even believe we're having this discussion, but here we are. Exposing one's private parts in a public place in the presence of others, that may not be a great fit. This is also a misdemeanor and would not subject someone to winding up on the sex offender registry, which is the question that keeps coming up. A third possibility is North Carolina has a peeping Tom statute. It requires being in the bathroom, though, to view someone else's body or underclothing. That, too, is not a great fit. Even even using the criminal trespass statute leaves some questions open about whose property is being trespassed on and to what extent and what public property is covered by the criminal trespass statute. We have seen problems with the statute in the protests that have been called Moral Monday protests in North Carolina, so it is not completely clear, whether even this statute would apply.
Yeah, Darcy, would you mind if I jump in on that one too?
Sure.
I just want to say that, our view is there no criminal penalties could possibly lawfully be applied here. I mean, this is a civil statute, and one of the requirements of any criminal statute is it has to be clear to a reasonable person. And the idea that by passing a civil law that you somehow have silently or implicitly created a new criminal offense or allowed people to be prosecuted for violating the civil statute under a criminal law is just so completely foreign to the most basic notions of due process and notice and the requirement of criminal intent and all that. I mean, I would feel very confident that any attempt to do that would be struck down and cut short very quickly. I'm really concerned, and I know others are as well, that transgender people all across the state of North Carolina and their families or parents of transgender kids may be worried about getting criminally prosecuted. And I mean, the message we're trying to get out to folks is that they don't need to worry about that. And in fact, I hope that people will just continue, transgender people should just continue to use the appropriate restrooms if possible. I mean, I realize, of course, if someone's working for an employer and you're directly ordered not to, that's you're probably not going to be able to. But our view too, and this is the premise of the lawsuit, is that Title IX and Title VII. Title IX applies to schools, and Title VII applies to employers. That they both require, as a matter of federal law, they require schools and employers to provide equal access to transgender students and workers, respectively. So the message that we and others are also putting out to schools and employers is you have to continue following federal law. And I'm hopeful that most schools, for example, will continue to do that. And I know it's really early days, and it's hard to know. It's just been a few days since the law took effect. But so far, it appears, just based on what we're hearing from the families that we've been in touch with, that schools are not rushing to change their policies, and the schools that have been, affirming transgender students are continuing to do so. And I really hope they should continue to do so. And if they don't, I think what we'll see is a lot more lawsuits. And same with private employers. Commissioner Feldblum from the EEOC just put out a statement saying that the view of the EEOC is that Title VII continues to apply in North Carolina. Of course it does. It's a federal statute. And that all employers in North Carolina that fall under Title VII's jurisdiction have to continue to permit transgender people to use the right bathrooms, and that if they don't, the EEOC is prepared to take action. So we're doing our best to kind of get that word out to folks in the state.
That's really important to hear. Thank you so much for explaining that to us. If you have questions, please email us at info@ lgbtbar.org. Any questions, info@lgbtbar.org, and we will relay those on to our two speakers. You're joining us here with Shannon Minter from NCLR and Professor Maxine Eichner of the University of North Carolina, Chapel Hill. And the questions that we're getting on our end, it really kind of boils down to this. Why here, why now? I suspect, Professor, you've asked yourself this question many times. Why North Carolina? Why now? We have known for a long time that there is a broad wave of so-called bathroom bills throughout the country. I believe the last time I heard Mara from NCTE speak on it, she said there was 150 or so that she had counted out there. Why here, why now, North Carolina, Professor?
Well, we, just to go back for a few years, North Carolina had been seen as one of the most progressive states on a number of issues. I would not have put us at the head of the list regarding LGBT issues, but neither were we at the tail of the list as we seem to be now. Legislature turned over in 2010, and in those mid-year mid-year presidential elections, we saw Republicans take over in both houses, and they were a new set of Republicans. And on LGBT issues, I do think they were at the tail end of the list. One of their first actions when the new Congress got in session was to pass through the legislature what became known as Amendment 1, which made us the 31st state to have a prohibition on same-sex marriage in our Constitution. They followed that up with lawsuits against same-sex marriage, which they appealed all the way through the Supreme Court. Mm-hmm. And then a bill exempting magistrates and court clerk officials from same-sex marriage. My understanding from talking to folks at the legislature is they do see this as a tool to energize their base. The political gerrymandering that we've had in North Carolina makes some seats very safe, and in an election year, they still want to bring out their base, and this is seen as a great tool to do that. I will say that I do think they are surprised by the pushback, and they didn't bargain for it. They didn't. They tried to leave time for it to. Not to avoid it on the front end, but now they're hearing it on the tail end, and what happens from here will be interesting.
I'm delighted to hear they're surprised about the pushback, so I guess it just means more of the same is what we should be doing. Is that right? I have in front of me the statement made by Hy Feldblum, one of the EEOC commissioners, and we are now putting it out on the LGBT Bar's Facebook page. So for those of you who are seeking it, you need no longer write in looking for it. It will be on our Facebook page. And we are delighted. Hy is a longtime speaker at our Lavender Law Conference. We're delighted that she has written What You Should Know, EEOC and Enforcement Protections for LGBT Workers. I should also mention Elizabeth Barrett has put something out from GLSEN about what you need to know and where you can make complaints. Not surprisingly, in today's world, some of our best information is coming in and going out through Facebook on this matter. So, Shannon, can we just go a little bit more broadly here about this wave of bathroom bills? I mean, it seems particularly unfair to me that what I'm going to call bullies in the legislature are picking on trans youths in schools. We know for a fact that those children within the LGBT community are some of the highest risk for self-harm, which is a long way of saying all of us have to do what we can for our own self-care and reach out to others within the LGBT community to help keep ourselves safe. So can you talk a little bit about these bathroom bills sweeping the nation, Shannon?
Yeah, and you're so right, Darcy. It really is shocking that politicians, elected officials would target such a vulnerable group of young people. I can't recall seeing anything that toxic or mean-spirited in a long time. And I think the reason that we're seeing so much focus on the bathroom issue and transgender people in the bathrooms is the perception on their part that is a weak spot for us. That the public doesn't understand transgender people, and so there isn't as much public support for transgender people as there is for lesbian, gay, and bisexual people. And they're able to call upon some really old, deep-seated stereotypes about predators, child molesters, preying on and really exploiting people's fears about the safety of women and children and the vulnerability of women and girls in particular to sexual harassment and abuse, which of course that is a very real thing. And to take advantage of people's anxiety and fears about that very real issue and then try to link it irrationally to transgender people is a very underhanded political tactic, but it's one that I think the extreme right in this country thinks is going to play out well for them. I'm actually confident that the public is smarter than that and sort of better than that, and that it will ultimately backfire. And I think as Professor Eichner noted, the depth of the response to North Carolina has been so incredibly encouraging and heartening, and I do believe we're going to see that in other places too. And I'm so glad that so far no other state has passed a law that targets transgender kids and adults around the bathroom issue the way that North Carolina has. Tennessee has come very close, and there is a similar bill that is died in one committee in Tennessee a week ago and has unfortunately been revived and is going to be heard in a new committee in the Tennessee legislature Tuesday of next week. So I hope everyone on the phone will go to the internet and find the committee members in Tennessee. The advocates on the ground in Tennessee are really asking all of us to write letters and send emails to the legislators in that particular committee. And Darcy, maybe this is something you all could post on the website as well, because we certainly need to see that bill defeated. And then I'm sure people may have seen all the news coverage. Mississippi also has a very bad bill that includes some really awful provisions about transgender people in bathrooms that's moving forward in that state legislature as well. But one more just quick thing on this, Darcy, if you don't mind. I just want to stress, and I'm so glad to have a chance to say this to everyone on the phone, that I think it's important that all of us not take the bait and not let the conversation about these bills and about this issue be focused too narrowly on bathrooms. Of course, I mean, these laws do have a very negative practical effect on people's ability to access bathrooms. But the same way that sodomy laws, for example, were really not just about prohibiting a certain sexual act, but were really about stigmatizing and trying to exclude all gay people, a whole group of people from the ability to be respected and recognized and participate in public life and be treated equally. That's what these bathroom bills are doing with transgender people. So to the extent we can all try to remember that and not get pulled down into the weeds of, what bathroom policy should be. But, I mean, this is really about whether transgender people have a right to exist at all and whether they have a right to be treated equally and included and respected. And the purpose of these laws is to send a very clear message that they don't, that they shouldn't exist, that transgender students shouldn't be in school, that transgender workers shouldn't be in the workplace, and that those of us who are transgender should somehow just be hidden out of sight and not allowed to participate or be included openly in schools and the workplace. So appreciate the chance to share that thought with folks.
Well, and it does, again, it strikes me as bullying to some of the folks who are the most vulnerable within our family. The concept that somebody would say that you're in a public place and you can't use the facilities has little to do with the facilities and more to do with a sense of bullying individuals, which it's really just so scary and so sad. So again, lawyers are probably the least equipped to handle issues involving self-care, and hopefully we're better equipped to handle matters of caring for others. So whenever possible, we are going to have to look out for all those folks within the family, especially as our T brothers and sisters numbers such a little percentage within our demographic. Is there a way that we can compare and contrast the situation with the governor of Indiana signing that bill there regarding broader LGBT discrimination? I mean, there seems to be, at least looking on Facebook, a perception that this is a political suicide for the governor of North Carolina. And I think it's easy for those of us who are frustrated and scared by these types of bills to kind of resort back to that. And we also know that governors are often surrounded by any number of yes men who will tell them that they should go ahead with whatever crazy idea is going on. Certainly the political fallout and the effect to the economy is going to mean something. Professor Eichner, is there anything you can say about the political situation as it relates to the governor right now? For instance, when is this individual up for re-election?
This individual is up for re-election this November. And as I said, our Attorney General, Roy Cooper, is running for governor against him. I think I am less sanguine about that political fallout hurting the governor in the next election. I say that only because I saw the maps a few years ago on voting on Amendment 1, and although in the cities and urban areas uniformly came out against Amendment 1, every rural area, the entire rest of the map of North Carolina, and that's a far bigger percentage of the map, voted in favor of it. And even though I think public opinion has moved somewhat, I don't know if it has moved enough. And there is no question that the governor's political call and the call of the leadership in the General Assembly is this will energize their base. I'm not confident that that's not the case.
Mm-hmm. Shannon, do you think we're going to see other bills like this used for this type of political expediency?
I think we'll see attempts to, for sure. But I think that's why it's so important that the momentum that's built up in North Carolina to oppose what happened there, the very negative response from businesses, and the response from states and localities across the country banning tax-funded travel to North Carolina is another really important thing, and that's something that people can do wherever they live. Urge your locality or your governor to ban taxpayer-funded travel to North Carolina. We actually have information about how to do that on the website, the National Center for Lesbian Rights website, if anybody's interested in following up on that. But I think it just remains to be seen whether there is a severe enough economic and political price paid for enacting laws like this. I mean, I think that will, determine to a great extent whether other elected officials decide that it is worth it to energize their base, as Professor Eichner said, or whether it's just going to cause too much damage to their state to risk it. And the answer to that question really depends on all of us in the broader community and all the LGBT allies, and whether or not the incredible response that we've seen to North Carolina, whether it continues to build momentum or not.
Shannon,
Right.
that sounds completely right to me. I do think public opinion public opinion is moving in North Carolina. I think it is not moving as quickly as it has in most of the rest of the nation, and to the extent to the extent there is indeed going to be some negative feedback from this decision, it's more likely going to come from the business community from outside of the state than it will come from the ballot box in November.
And I want to slow down here and reference what Shannon had mentioned, NCLR, hashtag We Are All NC, is recommending that each of us contact our state, county, and city leaders to ask them to stop taxpayer-funded travel to North Carolina. There is details on, help me out, Shannon, it's nclrights.org, correct?
Yeah, very good. Thanks, Darcy. That's exactly right.
Great. Something particularly appropriate, I think, for lawyers to do. As we know, it is going to be a long and slow road through the courts. So how far outgunned are we? Let's ask, as people continually kind of write in to ask, how did this happen? What can we do to make sure it's not happening elsewhere? Maybe we can just kind of take a broad analysis. We know we have dozens and dozens and dozens of these other bathroom bills that are out there. We know that the legislatures are trading upon really sad and extremely harmful, negative and incorrect concepts of trans folks and relative safety of bathrooms, et cetera. Where do we think that we're going to be seeing these our next kind of big issues coming from? And in light of that, Shannon, before we run out of time here, I want you to kind of understand this help me understand this within the larger work that you've been doing so successfully against so-called conversion therapy for trans folks. Can you give us a little bit of an update as how that campaign is going to help do away with this so-called conversion therapy?
Yeah, thanks, Darcy. Thanks so much for asking about that. Yes, we do have campaigns called the Born Perfect campaign with the very ambitious goal, but we're making good progress, of ending conversion therapy in the United States within the next 5 years. We've already passed laws in a number of states that prohibit state licensed therapists from engaging in conversion therapy with minors. We've had every major medical and mental health association in the country come out with very strong policy statements. We're really happy that the Department of Health and Human Services and actually President Obama himself and our current Surgeon General made a very strong statement last year, and based on a Human Health and Resources very in-depth analysis of the science that shows that attempts to change someone's sexual orientation or gender identity are ineffective and really harmful. Based on that analysis, the president condemned conversion therapy and encouraged families and parents to really educate themselves before they subject their child to such a harmful experience. We're also seeing a lot of international activity on this, with major human rights commissions and human rights organizations across the globe actually issuing similar statements. So I'm really encouraged by that. And I do think, to your larger question about can we beat what's happening in North Carolina and elsewhere, I absolutely think that we can. And I think the very same way that we saw the extreme right's attempt to outgun us and exploit irrational fears and stereotypes and abuse the political process to try to take rights away from gay people, in the marriage battle, with Prop 8 being the most infamous example, that ended up backfiring on them, and I think the same will happen here. I mean, in some ways, even though it's really terrifying, this is giving so much visibility to transgender issues and to transgender people, and I think that will ultimately be helpful to us. I think that is ultimately a conversation that once people start thinking about this issue and we have a chance to engage people in discussion in public education, we're going to actually end up probably accelerating the social and legal acceptance of transgender people considerably as a result of having to fight these battles in such an intense way right now. But that doesn't make it any less horrifying or any less terrifying for the families and the individuals affected right now in North Carolina.
Mm-hmm. Mm-hmm. Maxine, is there anything you'd like to add to the larger question of how badly outgunned are we? What is our likelihood of getting this resolved speedily so our trans folks in North Carolina feel safe?
So I think politically here in North Carolina there is no doubt we are outgunned for the foreseeable future until until we get redistricting in 2020. With that said, that's why we have more than one branch of government. I do think that courts will help us resolve this. I think that federal law will help us resolve this. In the political process, I don't think this is going to come from within. If there's going to be a shift, I would expect it's going to come from pushes from outside of the state. With that said, we've seen in Indiana that can make a difference, and we certainly hope that will make a difference here.
Mm-hmm. Mm-hmm. On a more positive note, and I'll allow you, Shannon, and Professor Maxine, to gather your thoughts. I'm going to ask you in a moment to think about the one kind of comment you want to, one nugget of thought that you want to leave.
Shannon and Dr. Eichner, if you both could kind of sum up with a final statement on North Carolina.
Shannon, you want to go ahead? Shannon? Can you all hear me?
Yes, you're coming through fine. Okay.
Final statement. We are in uncharted territory at this point. We hope for your help. This happened so quickly. We had no chance to deal with this before. In the aftermath, we are truly hoping that a galvanized national response will help change the situation. In the meantime, I am sure many of you know, but for others of you, the situation on the ground here is not a uniformly anti-LGBT, and I think here we have to particularly say the T part. There are lots of folks working here on the ground to try to do what we can with this situation, and if that doesn't mean repealing HB2 in its entirety, it means working to limit its interpretation as narrowly as we can. To the extent you have help to offer, we'd be very grateful. Thank you.
Thank you so much, Dr. Eichner, and thank you, Shannon, for joining us. It is a couple minutes past the hour, so we'll wrap up here. I'd like to thank everyone for joining us today. We will be posting this recording for anyone who was not able to join us early next week. And thank you again, everyone.